Morning, everyone. Welcome to the Utah Court of Appeals. We are here in the matter of 2021-0415 in Re Estate of Berrey. I am Judge Oliver and am joined this morning by Judge Luthi to my right and Judge Christensen Forster to my left. If we could have counsel make their appearances for the record, please.
Karthik Nadesan on behalf of appellant.
Thank you.
Matt Muir on behalf of appellee.
All right, and I see you have with you Mr. Brown, I believe.
Correct.
All right, thank you. Welcome, everyone. I see that I have 10 minutes on the clock, so you've reserved 5 for rebuttal. Is that correct?
That is correct.
All right. Before we proceed, I do have one procedural matter I wanted to raise with the parties. Referenced in the briefs and excerpted is what was labeled below as Exhibit W-1, which was the 2014 letter from David L. Berrey to his children. We have scoured the record and we cannot find that exhibit. We've looked in the electronic records to see if it's attached to anything. Unfortunately, we've been unable to find it. We also have 2 binders of hard copy documents. It's unfortunately not in there either. We do see in the record, in the transcript, where it was presented to the district court and admitted into evidence. I'm just not sure what happened to the letter. So I wanted to ask both sides if either or both of you have a copy of that letter and if that's something that you could supplement the record with for the court. Counsel?
I'm sure one of us have it somewhere.
I do have a copy. I'd be happy to supplement the record if council's agreeable.
And that would be terrific. It would be very much appreciated. And I do apologize. I don't know where it's gone, but we've been unable to find it. So we would appreciate that being supplemented. And with that, are there any questions before we begin?
No.
All right, please.
May it please the court, it's delightful to be here in person, although the weather outside is frightful. So,
Indeed it is.
but I'm glad we're here. The issue at the heart of this appeal is rather simple. A father, David L., promised his share of the family ranch to his son, David J. Years later, he changed his mind and he willed his ranch to his grandsons. The issue is, was he promissory stopped from doing that? Now, because this is an action in equity, the standard of review is a mixed question of fact and law. This court will normally defer to the trial court's factual findings unless there's a lack of adequate support in the record, but it reviews legal conclusions for correctness. Now, what's interesting about this appeal is that I'm sure when you read the briefs and you read through the background facts section, the background facts are almost identical between the 2 briefs. There's not really a disagreement about what the testimony was at trial and what the underlying facts are. Instead, the real issue is whether the district court made correct factual findings based upon that evidence and whether it made correct decisions of law based upon those evidence. So what I would like to do is start with the factual finding that I think is critical to this claim, which is, did David L. actually make a promise? Did he promise to give his share of the ranch to David J.? Now, the district court, in its findings of fact, didn't really make a finding one way or other about whether the promise was made or not made. Instead, it sort of implies that maybe the promise wasn't made, and it does so based upon 3 findings of fact. First, the promise conflicted with David L.'s wishes for the ranch as expressed in his estate planning documents. Number 2, other than David J.'s testimony, there was no corroborating evidence of the promise. And number 3, David L. never discussed the promise with either Brown, his accountant, or Betts, his granddaughter, but discussed his other plans for the ranch with them. All these 3 basic findings of fact all lack adequate evidentiary support. And I'll go through each one of them. The first is
just so that we know where you're headed with it.
Yes.
When you're done, are you going to suggest that we remand for additional findings, or are you going to suggest that something else?
What I would suggest is that I think the court has to remand if it finds that there is inadequate factual support. I think that there's no other option for this court. I think you can reverse the decision on the conclusions of law, but I think with findings of fact, the court has to say, no, there are inadequate findings to support these findings of fact, therefore you have to.
And that's where you're headed with this.
Right, exactly.
So help me understand I understand you think that the district court didn't make the correct conclusions from the evidence that was presented in making its findings of fact. So what I'd like you to do is help me understand where in the record you think there is evidence that the district court should have relied on to make findings in your favor. So,
Sure.
for instance, in your brief on page 28, I believe it is, you say in the first full paragraph that David J. testified about the kind of work he did, when he did it, and how much time and money he spent in respect to the promise. So can you point me to the record citations in the testimony below where he provides any testimony
Sure.
along those lines?
I believe that's in the background facts section, and I'm pulling this up right now. So it would be on page 9 of the brief. And the first full paragraph has the factual the record citations to David J's testimony.
Right, and so let's just begin with that citation. So it says, relying on David L's promise, David J., quote, spent several months doing research, end quote. That's not very specific or detailed. It's actually quite vague. So what did he do? When did he do it? How much time did he spend doing it? We don't have answers to any of those questions, correct?
That is correct.
Okay. And then the second sentence says he, quote, put a lot of work into saving the ranch from the railroad, end quote. What work did he put in besides the research? Do we have any evidence of anything he did?
Well, we just have his testimony and the testimony that's cited. We don't have any
Right.
other evidence other than that testimony.
So the only evidence in the record is his testimony.
Correct.
And his only testimony are these two things, that he
No.
spent several months doing research and that he spent a lot of work
Well-
saving it from the railroad.
Yes and no. So that's his only testimony about what he did with respect to the Union Pacific issue. But detrimental reliance goes further beyond what he did, because this isn't a promise, so we're not looking at whether this isn't a contract, so we're not looking to whether he fulfilled, his side of a contract. Instead, detrimental reliance looks at what did David J. do based on that promise. And so not only did he do the Union Pacific work, but he did the additional work that's identified in this passage. That is, he worked on the ranch, he restored a house and moved into it. He maintained the ranch, he did fencing work, he went and he had an argument with cousins about the lease
Right,
of
but
property.
isn't there testimony from David J. that he was gonna do that anyway? And because he loved the ranch, he had a connection to the ranch, and I believe he admitted at trial that he recognized that wasn't gonna help him with his promissory estoppel claim.
I don't think that's actually correct. I think what he said was, I didn't do this in order to further my promissory estoppel claim. But he didn't say that, yes, I would, I did this because out of my love for the ranch. Certainly, he would not have built a house at the ranch and lived at the ranch.
Well, let me stop you, because I think he actually said just that. So I'm on page 2357 of the record, and he says, this is starting in line 15, but definitely I did a lot of work there. And then he continues, I bought tractors that have been working there, I bought a horse, I bought gates, thousands of dollars worth of gates, I brought crews up there. And then he continues and he says, and this is on line 21, I went up after knowing that that wasn't going to qualify for any estoppel claim. I did that just to protect the ranch because it was falling apart. I don't expect that to be rewarded in an estoppel claim. Isn't that him admitting that he was doing the work anyway and not related to any claim he had for promissory estoppel and the promise?
I don't actually believe that's the case. And the reason why is because the promissory estoppel issue wasn't at issue when he did those things. So I think when he says that I didn't do this in order to further my promissory estoppel claim, it was because it wasn't an issue. He wasn't doing any of these things because he believed he had a promissory estoppel claim that he was trying to build up a detrimental reliance argument for. He was doing these things because at the time they needed to be done.
So is your argument then that anything he did connected to the ranch after the date of the promise in 2007 was detrimental reliance by David J?
That is my position, yes.
Okay.
Reasonable detrimental reliance.
Correct.
I have, in that paragraph of findings where you've identified that there were statements about some factual things but not an ultimate finding on whether the promise was made, there is in that paragraph a definite finding that the alleged promise was not clear and definite as required. What is your response to that in particular as to when David L. would transfer the ranch to David J?
Correct. So I think first of all, there's a conflict internally within the district court's conclusions of law there. Because right before that paragraph, he says there was a contract between the parties. And it's hard to say that there wasn't a definite and clear promise if there was sufficient clarity in the offer and acceptance to create a contract. So I think as an initial matter, there's an internal contradiction. But I think what's more important is the idea of promissory estoppel is we don't have to have the level of detail that you have in a contract. Instead, it's what the parties would objectively and reasonably have understood under the circumstances. Now here, where David L. was saying that, I think it was clear to everyone that David L. was making a promise about what would happen to the ranch after he died. I don't think it needed to be expressly said because I think it was clear to everyone that David L. wasn't going to give David J. the ranch, the day after he saved the ranch.
And in that respect, then, when did the promissory estoppel cause of action accrue? Does it accrue before death? And I think an argument that could be made that it does is that in a contract action, we can have anticipatory breach of a contract promise. Why should we not have anticipatory breach of a promissory estoppel promise?
Well, I think this is where it's interesting because I think under anticipatory breach, there are two ways a party can approach anticipatory breach, at least in the contract sense, which is if someone anticipatorily breaches, you can either treat it as an immediate breach or you can wait and see whether there's an actual breach. That is, if someone says, I'm not going to perform the contract, they might still perform it. There's no reason to bring a cause of action until the time of performance occurs and they've breached. Now here, I believe that the actual promissory estoppel breach of action only occurred in 2015 when the trust was changed so that the ranch was no longer going to David J. But of course, no one knew that because the 2015 trust and those changes only became public knowledge after Mr. David L. died. So here, I think the first issue is the breach and the promissory estoppel cause of action only accrued when David L. changed his will, when he actually broke his promise. And I think another important part is that there was no awareness of that breach because even in terms of the anticipatory repudiation, there was no clear statement from David L. saying, hey, I know I made this promise, but I'm not going to keep it. Instead, the answer is that he was silent in the conversation where David J. brought up the promise, but what he did afterwards was he didn't sell the ranch and he didn't act in a way that was directly contrary to the promise that was made.
But I guess I want a little more clarification about that in the sense of he did act in direct contradiction to the promise, right? By saying I'm going to sell the ranch to the grandson.
Correct.
By the letter that we're actually missing, the letter to the children saying it's all yours, right? All of you, not and you make a good point that that letter does not actually say that they're going to get it evenly, right? The distribution will be
They
evenly.
all were entitled to part of the ranch as a result of the family trust. So with the district court and the issue that David J. actually won was that the family trust portion had to be divided equally between the children. So the letter was accurate in that all of the children were going to get a portion of the ranch.
So I guess the question is what does one who is expecting, who is relying on a promise, how much do they have to take to know that that promise is not gonna come to pass? Like, was there any obligation on David J. when David L. was doing these things to say, hey, Dad, remember our promise, I'm still counting on it? Like, does he have an obligation to act?
Well, I guess there are two answers to that. The first is, I don't believe he has an obligation to act until the promise is actually broken. But other than that, I think he actually did act, which is he did visit David L. and he did have the conversation. He said, remember the promise you made. And after that visit, David L. didn't sell the ranch.
I have one other question, if that's all right.
Go ahead.
In one of the statements that appears repeatedly in our case law about promissory estoppel, and it's cited by the district court, is that the remedy granted for breach in promissory estoppel may be limited as justice requires. And that seems that the court made a finding based on that proposition of equity, that the court finds that it would be inequitable to award David 1/2 or more ownership of the ranch based on the scant amount of evidence.
Right, and I think.
How did the court abuse the discretion that it's granted to say, I kind of read it as that the court saying, even if there was reasonable reliance, detrimental reliance on the promise, I only have testimony of, I did a bunch of research and some stuff about the railroad. Is that really enough to give you more than half of this ranch property? And no, it's not, it's negligible. And so even if we nominally were to say, yes, your promissory estoppel claim is proven, we're gonna limit that remedy based on your scant evidence of what you actually did. Where's the abuse of discretion there?
So I think that's a really good issue that needs some clarification, because I think the district court erred there, because it didn't adopt the reasoning that you just gave me. Instead, it made two mistakes. The first is, it said, I'm gonna base this on the scant evidence, so not on the actual testimony that was in front of it, the facts that were established by the evidence. It said instead, I'm gonna base it on the fact that you didn't provide documentation of what you did, and you didn't provide exact dates and details of what you did. So it wasn't really based on, hey, you've got unrebutted testimony about what you did, and I'm gonna consider that testimony, and therefore I based it on that, and I find it inequitable.
It's his burden to put that evidence on, though, isn't it?
Oh, sure.
Lack of evidence is evidence.
I'm not saying that it's a burden issue. I'm saying that the district court's standard, though, was not, hey, there wasn't, the evidence, what you established isn't enough. What it says was, you didn't provide me with sufficient evidence, with documentation, et cetera. So it didn't say, here's what I found that you did, and I find that that's not enough. Instead, it said, you didn't provide me with enough for it to be equitable. But if you provided me with documentation, I would have reached a different decision. So I think that's the first error that the court made. I think the second is, it didn't do that equitable judgment, balancing act that you just mentioned, which is, it said, hey, listen, I based on what you've given me on detrimental reliance, I don't think I can go all the way as to give you this part of the ranch. But here's what I can give you, which I think is equitable. So here's the limitation under the circumstances that you've established. And it didn't make that analysis. Instead, it said, hey, you don't get anything, which I think is not what you were quoting as the standard.
I think if the evidence quoted by Judge Oliver earlier, if that's all that the court credited and didn't credit the later building of the cabin and that sort of thing, but merely his testimony that, hey, I did research for some months and did something about the railroad, it seems like that's scant enough to say that's negligible.
That may be the case, but unfortunately, the district court didn't provide us with enough factual findings to actually say one way or the other what it considered and what it didn't consider when it made that decision.
Thank you.
All right, thank you. We'll
Thank
give
you.
you your full time for rebuttal.
Good morning. May it please the court, Matt Muir for Mr. Brown. In our brief, we cited to the court the case of Lunt v. Lance. In that case, it had to do with some prescriptive easements, and the appellant came to the court and in its brief outlined the testimony of various witnesses and then went through an analysis talking about the relative strengths and weaknesses of the testimony that had been received to those witnesses. And what the Court of Appeals said, in essence, was what you're asking us to do is to reweigh the testimony and to rejudge the credibility of the witnesses. And that's not appropriate on appeal. That's for the finder of fact, which in this case was the trial court who was there and who had access in real time to those witnesses, to the testimony, and had the task of weighing that evidence and judging credibility. And I think that has been Mr. Berrey's approach in this appeal. He has pointed out certain points of the evidence and then suggested to the court that the trial court misconsidered them or didn't give them enough weight or did not draw the appropriate reasonable inferences from them. And I don't think that approach is appropriate in this appeal. And there was sufficient evidence for the court's factual and legal findings and sufficient basis on which the court could draw reasonable inferences from the evidence to support its findings. And so if we start with the conclusion that the promise was not sufficiently clear as required by the law, there's support for that. As the court just noted, the absence of evidence is evidence and can lead to reasonable inferences. So it is literally just those two sentences that were highlighted during the argument already, about what the promise was. Well, it's just one sentence. David, if you get us out of this jam with the Union Pacific, I'll give you my half of the ranch.
And let me interrupt you there.
Yes.
I'll be blunt. I have no idea what the issue with the Union Pacific Railroad is in reviewing the record. I don't know what the jam, I don't understand what it was, but it doesn't seem to be disputed that he fixed it, whatever it was, right? The evidence was clear that he saved the ranch from the railroad, I think is the phrase that's used. So that's not disputed, at least. Am I correct in understanding
That
that?
testimony is not disputed. It is what it is. I mean,
Okay.
David J. is the only source for that. There were no corroborating witnesses, no documents. So I don't know either. There is no evidence of what the problem was. There is no evidence of what exactly David J. did, when he did it. There's no evidence of what harm could have befallen the ranch had he not done whatever it is that he had done. So it's all rather vague, and I think that was key in the trial court's decision.
There are a couple of statements by the trial court about, that seem to express skepticism as to whether the promise was actually made, but no finding on that. Do you need a finding that the promise was made?
No, I don't think you do. I don't know that the trial court reached that ultimate finding. I don't know that it had to. I think what the court said was David J. did not meet his burden of proof, improving a clear and definite promise or improving adequately detrimental reliance on that promise. And that's all the trial court needed to do. Significant in regard to the promise to the trial court was the lack of corroborating evidence. David J. has pointed to, I think, a couple things that he says, well, there is corroborating evidence. He points to the fact that David L. Sometime later appointed him manager of the Idaho LLC. To assume that that is corroborating evidence is to make an inference that the trial court did not make. And David J. is asking this court to now step in and make that inference inappropriately. There is no evidence as to why that management appointment was made, none at all. And it could have been a host of reasons. He also points to the 2003 handwritten will in which David L. wrote that David J. would get 50% of the ranch. I don't see that as corroborating evidence of the promise. I see it as the exact opposite. If David L. had already given David J. 50% or was obligated to do so under that 2003 will, why would he then hold it over David J.'s head 4 years later and say, only if you do this will you get 50%? I see it as the opposite of corroborating evidence.
But I believe David J's response to that would be that he didn't know about the will, the 2003 will, right?
Yeah, that's not disputed.
Okay.
But it still begs the question is why David L. would be doing that if he'd already given him half. I do think it's significant, as did the trial court, that no one else in the family had ever heard of this promise. We pointed out 2 examples. Miss Betts, who was particularly close with David L. and his first wife, Roberta, practically raised by them, was her testimony. She did have a period of time after David L. Married his second wife that they were somewhat estranged. But critically, she testified that by 2006, so before the alleged promise, her relationship with David L. was on good terms. And
I'm
that's
sorry to
it.
interrupt you.
Yeah.
These pieces of evidence seem to me to go to whether there was a promise. And you've told us that part doesn't matter so much. That really, maybe what matters more is the more specific finding that the promise was not definite enough. And I'm curious, how do these pieces of evidence that you're pointing to go to whether the promise was definite?
I don't know that
And the trial
they
court essentially talked about when it would be transferred. It wasn't definite as to when it would be transferred, and I don't know that these pieces of evidence go to definiteness of the promise.
I agree. I think they go to more to whether David J. met his burden of proof in establishing this element of his claim, and not necessarily whether the promise was definite enough or not. I do want to point out that contrary to, I think, what was in the appellant's briefing, it is in the record that Alice had many conversations with David L. throughout her life about what he was going to do with the ranch. That's at 2441. Mr. Brown's in the same boat, and it's in the record that he had conversations about what David L. was going to do with the ranch. And also that David L. told him in the fall of 2015 that he wanted the ranch to go to the grandsons. So that's all in the record. Moving to the issue of reliance, again, the court found that the evidence presented, which was scant, to use the trial court's word, was not enough. And I think it's important in the Hughes case that we cited, the court notes that the court of equity has power in devising its remedy and shaping it so as to fit the changing circumstances of every case and the complex relations of the parties. And so the trial court had that ability, and the question was posed earlier, or Mr. Berry's counsel made the point, well, the court didn't consider giving something lesser, but I think it's important to consider that David J. did not ask for anything else. All he wanted was the 50% of the ranch. Had he come in with a damage claim, for example, hey, I spent this much of my time, which was worth X amount of dollars, or I spent this much money out of my pocket, perhaps the trial court could have considered something lesser. But no such evidence was presented. There was one claim and one claim only: I want half the ranch.
Could I ask you about the statute of limitations and when it
Absolutely.
accrued? I've not found case law in Utah or anywhere else where anticipatory breach of a promise has given rise to a promissory estoppel claim, where a court has said that concept of anticipatory breach triggers a promissory estoppel claim. Why did it not accrue, well, until the time of David L.'s death?
I think David L. made things very, very clear in the spring, summer, and fall of 2014 when he took the steps. He distributed a gimme permission to sell the JR document to everybody. He then met with David J. and did not reiterate his promise. He then sent that letter, which I understand the court is missing, and will supplement that, that very, very clearly said, I'm giving this to everybody. And it is a good point. He didn't say how much was going to everyone, but I think it made it clear at that point that it seemed to be back to the original intent, which was to give the kids equal shares. The court's right there. I haven't seen that case law either. I would note that I don't know that this court even needs to reach the statute of limitations issue. I think the key finding by the trial court was David J.'s failure to meet his burden of proof on the elements of his promissory estoppel claim. And if that is affirmed, the statute of limitations or this argument that there was a contract doesn't need to be reached. Does the court have any questions about the issue that the appellant raised about the difficulties with the electronic trial and and why that somehow should cause this court to limit the discretion the trial court had. That issue wasn't raised during argument yet today, but I just want to make sure there aren't any questions. Otherwise, I don't intend to address it.
I don't think there are any questions on that particular issue.
Okay.
It was a difficult road to get this record.
Very
I
much so,
think we can all acknowledge
for
that.
various reasons.
Yes.
I guess to sum up, I would note, just remind the court of the immense discretion the trial court had in this equitable matter and its ability to shape the remedy given the complex relations. There are 18 beneficiaries to these trusts other than David J., including his 3 living sisters, 16 grandchildren, of which include David J.'s own 4 children, none of whom have appeared to support his position. Some of the beneficiaries did appear in trial court in opposition to his position, including his 2 sisters and some of the granddaughters. Everyone's been waiting for this issue to be sorted out, and we request that this court affirm the trial court so that all these people can get their inheritance and move forward. Unless there's any other questions, I'll submit.
All right, thank you. All right, rebuttal?
I'm just gonna briefly go through some points, and obviously, you'll feel free to interrupt me.
We will, thank you.
The corroborating evidence issue, I think, again, the real issue here is, did the findings of fact that the trial court reached, that is, there's no corroborating evidence, did that address the undisputed testimony in the record? And just to address that really quickly, the manager issue isn't just that at some point he was made manager. The issue is that he was made manager after he won on the Union Pacific issue, and he was removed as manager in 2015 when at the same time, David L. changed his trust to change the ranch over to the grandsons. So I think that becomes strong corroborating evidence that the managerial appointment was part of giving the ranch to David J. Similarly with the 2003 will, I think you pointed out that he didn't know, David J. did not know about the will, but David L.'s motivation for making the promise is simple. David J. said, I'm not willing to invest the time and effort into helping with Union Pacific if I don't get a larger share of the ranch, if I've got to buy out my sisters. And David L. wanted to motivate him. And so he said, hey, you do this, you'll get my share of the ranch. Now, what's really important when we're talking about the estate plans, what Brown and Betts knew, was that David L. didn't tell anyone anything. I mean, that's what's really clear from the record. Everything that he did in terms of estate planning was a secret. He didn't tell David J. about the 2003 will, he didn't tell Brown about it, he didn't tell Betts about it, he didn't tell anyone. When he changed the will again in 2015, he didn't tell Brown about it, he said, I'm changing stuff, but he didn't say it. Brown said he was surprised when he found the disposition after David L. He found what was going on with how the ranch was being disposed of, how the Bear Lake property was being disposed of. Betts was surprised and she was upset. David L. kept all this stuff close to his chest. So it's hard to look at the district court saying, hey, he didn't tell anyone else about this, when that was characteristic of how David L. did stuff in terms of estate plans. Certainly he may have talked to them about day-to-day operations and his plans for the ranch, but he did not discuss with Brown and Betts where he intended the ranch to go when he died. There was a talk about the remedy and the fact that all that David L. asked for was his share of the ranch versus a damage quotation or something. But that's not how promissory estoppel works. Promissory estoppel says, hey, I would like you to fulfill your promise. And it's up to the district court in its equitable discretion to say, hey, you're not entitled to the entire share of the ranch. Based upon what you've said, you're only entitled to this much. It's not up to David to sort of negotiate with the district court about what amount he should get. That's what the court decides.
I guess I do have a question about that, though.
Sure.
I mean, isn't this kind of an all or nothing situation?
I don't think so. I think that's
How
where.
come?
Because when we talk about the court having the authority to limit the remedy according to the equities, I think what you do is you've got to ask the court, hey, this is what I want. And then the court has to say, well, I can't give you all of that because that would be inequitable. But here's what I think the fair outcome is, because I think that's what a remedy at equity is, right, versus an equity at law, a remedy at law.
Yeah, but the trial court can only act in an equitable manner if the plaintiff proves equitable estoppel, right, or promissory estoppel.
Sure.
Not equitable estoppel, promissory estoppel. And that is the court's ultimate finding, right, that Mr. Berrey did not prove.
Correct.
His
So
claim.
that's a different issue. So if the court finds there's promissory estoppel, and then it comes to the remedy can be, hey, listen, I can't give you the entire remedy you're asking for, but I can give you this much. But yes, you're correct. The court first has to find that the promissory estoppel is there, but once it makes that finding, then it has discretion.
Is it really procedurally, is the plaintiff allowed to wait until the court decides, well, I can't give you all of it? Is the court then obligated to say, so let's reopen trial, reopen the evidence? You didn't really give me the numbers that I need to give you a slice of the pie. Now that you know I'm only going to give you a slice, go ahead and produce your numbers. It seems like you've got to put those numbers in at the outset, which David J. did not do, unless we're going to talk about the cabin. But in terms of what he did to save the ranch from the railroad, he did not give any numbers, nothing that's quantifiable. And so,
Correct.
so if the trial court says, maybe I'd give you a slice of the pie, does the trial court then have to reopen the evidence?
No. So I think what happens is that if the trial court finds this promissory estoppel, then based upon the evidence before it, it decides what the slice of the pie is.
And would you agree that there's not enough evidence here to calculate a slice size?
That's where I disagree, because I think it's undisputed. I think the court itself has said today, he saved the ranch. Well, how much is saving the ranch worth? Right? So the question
What does
is.
saving the ranch mean?
Well,
I don't understand what the ranch was saved from,
well, my
or who
understanding.
the ranch was saved
My
from.
understanding from reading the record, I was not at the trial, so,
You're in the same boat as us.
Right. My understanding was that Union Pacific was closing railroad crossings so the ranch people could communicate through the ranch, and so one side was split from the other, and it was no longer economically practical to run the ranch. And
Which
so-
that statement itself gives us a different meaning of save the ranch than we would have lost all of it.
Well, my understanding, yeah, I mean, I guess we're all sort of trying to make inferences here from the record. But that was my understanding, was that the ranch was no longer economically viable if you couldn't access the both sides. And so the fight with Union Pacific was to stop these railroad crossings from being closed down. But I guess the question then is, well, are we looking at, how much time you spent? Are we trying to measure that? Because that obviously is sort of an interesting question, right? What's your time worth? What's going on? Or is the question, hey, here's what you did. You worked on this Union Pacific issue. You prevailed. It saved the ranch. Is that sufficient as detrimental reliance? Did you help the ranch out? Did it take your time? Did it take your effort? And I think that's, if we limit it only to what he did right after the promise. But I think that, I also believe that the court has to go further and say, what were all your actions that you did based upon the promise? And I just one last issue, which was about the credibility issue, which is, I think it's both an important issue and not, in the sense that the district court didn't make any credibility determinations in its findings of fact. It never said, hey, I don't believe this person. It didn't make any of those. But I think also when the court's looking at it, that there might be a temptation to say, well, the district court made a credibility determination. But I think under the circumstances of this case, and especially with the state of the audio, because I think this was at the start of the pandemic, or in the middle of the pandemic when WebEx was not the WebEx it is now, I think the credibility determinations were very, very difficult to make given those circumstances. Thank you.
All right, thank you. Thank you to both counsel this morning for your arguments. We appreciate that and your answers to our questions. we will take this matter under advisement and issue an opinion as soon as we are able to do so. And with that, the court will be adjourned for today. Thank you.
Thank you.